the basis of that argument, because we are arguing our application with both facts and the law. So I'm doing the law, then my colleague will do the facts. It's the same thing if we started with the facts. So I'm almost done with the law. But sometimes he does that to take me off-road, and he knows I never get off-road. So, Your Honor, I was inviting the court to paragraph 24 of the very erudite decision of learned Justice Joel Ngugi, which sets the test required for the grant of the order of detention continuing, which my other colleagues prefer to call custodial orders. And it says, at paragraph 24, if you permit me to read, so, even while accepting that the text of Article 49(1)(f) may, in certain circumstances and contexts, and we submit like this one, comprehend a situation where a person is presented before a court without being formally charged, and is thereby informed of the reasons for his continued detention through the state's application, like ours, to have him so held, the state must satisfy a double test. A, first, the state must persuade the court that it is acting in absolute good faith and that the continued detention of the individual without a charge being preferred, whether provisional or otherwise, is inevitable due to existing exceptional circumstances. So that, Your Honor, through the factual matrix, we are going to establish exceptional circumstances. And B, this is the second part of the test. Second, the state must demonstrate that the continued detention of the individual without charge is the least restrictive action it can take in balancing the quadruple interest. Now, this is very interesting. Quadruple interests present in a potential criminal trial. There is a potential criminal trial, and this is the quadruple interest. Number one, the rights of the accused individual, in this case the respondent, who is likely to be charged in a potential criminal trial. Number two, the public interest, order, and security. You know, it is not in doubt that this is one of the great matters of the greatest public interest in the country at the moment. Number three, the needs to preserve the integrity of the administration of justice. We will discuss that in a minute. And finally, and the interests of victims of crime where appropriate. And Your Honor, the court, in cracking its head about it, continues to say, by virtue of Articles 21(1) and 259 of the Constitution, the court must act to aggrandize, not diminish, the personal liberties of arrested individuals in line with the other three interests. But importantly, differently put, the state must demonstrate that there are compelling reasons to deny pre-charge bail, while balancing all factors within the complex permutation presented by these quadruple interests, and without reifying or essentializing any. Yon, I dare say kizungu kubwa. Having highlighted those two tests, Your Honor, the state is acting in utmost absolute good faith to have presented the respondent within a reasonable time before court. Other than in the police cells, through the affidavit before you, the respondent has been informed, one, of the reason of his arrest, and two, of the reason why the state seeks to continue to detain him. That is a show of utmost good faith. Your Honor, in insurance law, it's called uberimai fidei. That good faith is furthered by the fact, as my learned senior will tell you in the facts, or rather in the affidavit, that there has been some investigations ongoing and that we just need a limited period within which to complete those investigations. And finally, from my part, in compliance with the need provided for under Article 24 of the Constitution, that the limited detention of the respondent is the least restrictive measure we could adopt to protect both the interests of the respondent, the victim's interests, and as equally important, the interests of the public to ensure safety and security. With that legal background, I invite my learned senior, Mr. Jalson Makori, to take you through the factual matrix in the affidavit. I am most obliged unless there's a question for me.
All right, thank you.
Thank you.
Your Honor Makori.
Yes.
Your Honor, we are referring to the affidavit by one Abdurrahman Jibri. Dated the 16th of June 2025. It is an affidavit in support of the notice of motion dated the 16th of June 2025. Your Honor, I will only highlight the paragraphs that are in the affidavit. Paragraph 6 sets out the background of the investigation, and these are the preliminary investigations by IPOA, which reveals in paragraph 6A to E, that is on the 4th of June 2025, the DCI received a complaint from the DIG of police, Mr. Eliud Langat, alleging he suffered continued false and malicious publications on an X account, formerly Twitter, with the username Pixel Pioneer, and requested investigations with a view to establish the person and motive behind it. Your Honor, A to E establishes the grounds in which the investigations were mounted. It is at paragraph 6B. On the 7th of June, the DCI team went to Linda Center in Homa Bay County and arrested the deceased at around 2:30 p.m. And they took him to Mawengo Police Station, placed him in custody with the OB number 10/7/7/6/2025. That is 10/7/6/2025. Then at around 3:54 p.m., the deceased was booked out under OB number 11/7/6/2025 and escorted to Nairobi, where he was booked at Central Police Station under OB 136/7/6/2025 at 9:32 p.m. Your Honor, we have annexed to paragraph 6E the OB extract, that is AJ1, indicating the time that the deceased was booked at Central Police Station. Paragraph 7, Your Honor, the respondent was arrested. And this is something that would wish the court to take notice. The respondent was arrested on the 13th June 2025 at 18:05 hours. That is 6:05, which was on a Friday. The respondent in paragraph 8 was informed of the reasons of the arrest and for which and the reasons and of the offense that is being investigated. That is under paragraph 8. Your Honor, in paragraph 10, now we are coming to the reasons why we want to continue holding the respondent. The respondent is the custodian of the station records, being an OCS, officer commanding station, and the surveillance system, the CCTV. And this is at the material time under the investigations. Your Honor,
the information the DPP is giving, it's not the who deformed. It is the one who deformed who should be giving us those paragraphs. We can talk about it because then the DPP can trust their submissions based on that. Right now, the DPP is turning himself into a witness. We cannot close the exam with the DPP. It is fair and just. The witness who deformed takes us through his adjudication.
Your Honor, as I said that I'll only highlight a few paragraphs which I wanted the court to take note of.
You know, that's a dicey, it's a dicey situation because
yes,
you're literally taking us through the affidavit, but I leave because I'm sure you have your own strategy
yes,
on how to prosecute the application.
The defense
got into details
yes,
of the affidavit. I'm sure the defendant will have a chance.
Yes.
So I'll leave it to proceed, but don't go too much into it.
No,
position.
No, Your Honor, I'm only highlighting some paragraphs. I'm not going through the whole affidavit because they have already indicated that they want the deponent on the dock for cross-examination. Yes. Your Honor, what we are
CCTV, maybe
yes, at the CCTV, yes, we said paragraph 10. The respondent is the custodian of the station records and the surveillance system, that is the CCTV, that is under investigation. Yes, investigations reveal that under paragraph 11, that the respondent, together with others who are not before court, hired a technician to interfere with the CCTV system at the Central Police Station in a bid to tamper and interfere with the subsequent investigations. Your Honor, we are highlighting what so far we have done insofar as investigations are undergoing. So there is still some investigations which we need, and that is the reason why we are asking for continuing detainment of the respondent, because the respondent's mobile phone has been detained. and it is subject to investigations. Your Honor, there are also witnesses who are yet to be investigated and statements taken from them. Also witnesses, police officers who are on duty at Central Police Station on that night. Your Honor, given that the respondent is the OCS, we are saying that there is a likelihood that he may interfere with the investigations. Your Honor, we'll be seeking the 21 days. To continue holding the respondent, and in addition to the 21 days, Your Honor, we'll be seeking an order that we access the phones of potential witnesses, the police officers who are on duty, and any other person who was at the vicinity at Central Police Station. And this, Your Honor, we are relying upon paragraph 17 and 18, where we have shown in the paragraphs, we have demonstrated that there is already interference which has already been done. With that, Your Honor, we will be inviting the deponent to the dock for the cross-examination.
Whenever you're comfortable.
Yes.
Yes. Cannot be seeking, but these are standing into an opening statement. Will be allowed at 3 minutes opening statement.
No, let him finish.
What?
Let him finish, and then you have your chance. Let him finish, so that there's that continuous thing. So let's
Yes.
Yes, please.
Bismillahirrahmanirrahim. Bismillahirrahmanirrahim. I swear by the name of the Almighty God, that the evidence I shall give before this court, touching the matter in question, shall be the truth, the whole truth, and nothing but the truth. So help me God. Your Honor, I am Abdurrahman Jibril. Jibril for you, Jibril. I'm a Senior Assistant Director, Investigations with the Independent Police and Oversight Authority.
Yes. Did you call this affidavit at the court?
Yes, Your Honor.
Yes, kindly proceed with the affidavit. There will be questions given from the defense.
Thank you, Your Honor. Your Honor, I am one of the investigating officers in the ongoing investigations that IPO is currently conducting in regards to the brutal murder of Albert Omondi Ojwang. This is pursuant to Section 6, 7, and 25 of the IPO Act. Your Honor, on 8th day of June 2025, IPOA learned the death of Albert Ojwang while in police custody at Central Police Station within Nairobi County. Your Honor, the authority immediately initiated investigations to unravel the circumstances surrounding the gruesome death of the deceased. Your Honor, so far, our preliminary investigations have revealed that the deceased was arrested following a complaint by the Deputy Inspector General of Police.
Your Honor, all that the witness is saying has been said. You can only adopt the report of the verdicts. Because unless there's any other crucial information.
That's another, Your Honor. That's okay.
Yeah, I was of the view, but just give a highlight, not necessarily going paragraph by paragraph, just a highlight, and then we can adopt it. Just a brief highlight.
Okay.
You okay with whatever you've said so far?
Yes.
And whatever you've averred in the affidavit, yeah? So we can proceed with the cross-examination?
Yes.
Is that okay? The other chap from the state?
That's actually not that.
Okay.
They can proceed to examine on the affidavit.
Thank you. Your Honor, I'll be asking the witness to deliberate.
So, Mr. Duncan, maybe just for housekeeping in good order, how many of you will cross-examine him?
3.
3. You, yourself, and who else?
Me, what? Kangai.
So only 3 of you from
Yes,
the
we'll
battery-
cross-examine it.
The 3
The
of you.
others will submit.
I think that is okay.
Thank you. Mr. Jibril,
Yes, Your Honor.
can you confirm your position at IPOA over this matter?
You're asking my rank? My,
Yes. That's a must.
Your Honor, as indicated, I'm a senior assistant director in investigations.
And confirm that you are an investigator.
Yes, Your Honor.
Are you an investigator in the purpose and the name or the position of the National Police Act?
IPO Act.
Under IPOA Act. And under IPOA Act, is it true that you have still arresting powers?
Yes.
Under which section?
Your Honor, Section 7 of the IPO Act and Section 7 of the IPO Regulation Act actually gives me the powers, privileges, and immunities of a police officer.
So Section 7. And which section?
Both Section 7 in the IPO Act and Section 7 of the IPO Regulations Act.
Gives you the powers as that of a police officer.
Yes, Your Honor.
And in this matter, you are now actively participating pursuant to those provisions as an investigator.
Yes, Your Honor.
Thank you. Are you well conversant with the law?
Depends on which area you want to ask.
Are you, you know, some of us went to teach, then we became lawyers. Some people are mad about that. Do you have any legal training?
Yes, yes, I do.
Could you refer the court to your legal training?
I'm an advocate of the High Court of Kenya.
Thank you. You are an advocate of the High Court of Kenya. Look at the Criminal Procedure Code, Section 386, as an advocate of the High Court of Kenya. Could you be given it?
Your Honor, we'll have an objection.
I've not asked the question.
We can see. Your Honor,
I've not asked a question.
Your Honor, at least should I be allowed to make the objection?
Yes.
Of course.
Let me just object, then you
No,
can...
no, no, no. You wait until I ask. I've just told to look at it. It might be just to admire it. Allow me to ask.
Your Honor, we'll be requesting the court to
Mr.
just...
Nelson Omar,
Yes.
let's hear his objection.
Okay,
That's right.
Yes, kind
Your Honor, the witness before the dock
Yes.
has come here on the basis of his affidavit on the factual matter. And that explains why the defense requested that my colleague, my learned senior, does not go into the facts. Section 386 of the Criminal Procedure Code, or whatever provision of the law, is a matter of law. And Your Honor, the objection again goes into the earlier intended preliminary objection, which we have had sight of, where the argument, in a sense, is that this matter, now we have had a copy, although it's not filed, this matter should have been the subject of an inquest and not a miscellaneous application. So that because we are alert, the defense should not try through the window to bring in a preliminary objection which they admitted not to have filed. But more importantly, that this is a witness of facts, not a witness of the law. We can deal with the law between the lawyers. Thank you.
Is the law a fact? Yes, it is. Is he in a court of law? Yes, he is. Is he an advocate? He knows it. What is it that they are fearing and telling us they are coming through the window? If you come through the window, please respond and throw us out of the house.
There is a submission.
You know,
I've not asked any question. I've only told you to look at that section.
but just for guidance, you know, it's a matter of evidence on the facts. It's an affidavit, for heaven's sake. So let's leave it to the facts of it.
After I've asked the question,
Yes.
then that is when an inference can be done, whether it's a question of law or a question of fact.
All right.
I've not asked what. I've only told you, look at section 3.
Your Honor, just one more thing. The reason we requested the defense at the very onset to inform us of the paragraphs is that the cross-examination is limited to the contents of the affidavit. There is no reference to section 386 in the affidavit. They cannot go to it because it is not a matter of fact. If you pointed to us the paragraph looking at section 386, which we referred to, there will be no objection from our end. But because affidavits are leadings of fact, we plead with you to reject the invitation of the witness to look at section 386 or any other provision of the law. Thank you.
I think he was referring to section 386.
Yeah, I just only
So
told you to.
let's not convolute it. Let's limit. It's an affidavit.
Purely, I've not asked any question, Your Honor. If we only had what I've asked, and I ask a question of law, then the court can stop.
Okay, then proceed and ask.
Let him have that. Let him look at what
But you know,
I've
once
done.
you point it to the law, then it means it's
No, no, no.
a point of law.
And that exactly is our objection, that we can't refer to the law. That is, maybe, see, a counsel is not understanding our objection.
Very well.
Maybe
Very well.
counsel, maybe rather than asking him to look at the law, why don't you put the questions to him?
Correct.
All right.
Just put the question
All right.
rather than us going
Very
to
well,
the.
very well, very well, very well. From your affidavit, confirm the place of death of the late.
Central Police Station cells, Your Honor.
Central Police Station cells. From the PO Act, provide the mandate for you to investigate somebody dead in a police cell.
Yes, Your Honor.
Read, show the court. because you have confirmed the scene of death is at the police cell. Which mandate gives you that power? Let him answer.
We are still objecting. Council is still taking the same route.
He came under the Act. Section in this miscellaneous application, paragraph 3, they must have said under which mandate they are coming before this court. And these are witnesses. He's not an advocate. Let him come in front of you. Let him not be given answers.
No, Your Honor. We plead with our colleagues to just remain respectful. We know that they are very good people. Let us maintain the decorum. What we are asking is, as the court has suggested, put the law to the witness. Don't ask the witness to follow the law.
Very well.
We do not mind if you read the law to him and ask questions.
Read paragraph 3 of the Act.
Please read for me so that I can answer.
No, you read it. I didn't write it.
Which one?
Paragraph 3.
That investigations by IPOA are pursuant to Section 6A, 7.1, and 25.1 of the IPOA Act.
Is that the law?
Yes.
Is that a fact or that is the law?
That is a fact as per this affidavit.
That's what I'm saying.
Yes.
You have quoted the law. True.
Yes.
Therefore, it is not wrong to ask you a question of law because it is you as in the affidavit talked the law. Give me the law that gives you mandate to investigate a person who dies in a police cell. What is it?
I have indicated the sections 6.1, 7.1, and 25.1.
Just tell the court.
Yeah, Honor, I have indicated section 6A, 7.1, and 25.1 of the IPO Act.
Could you kindly read to the court those sections that gives you that mandate? The IPO Act. Just read to the court those sections for the benefit of the whole one. We don't work for IPO.
Because we did not anticipate that a witness of fact will be made to read the law, we didn't carry a copy of the IPOA Act. If they insist that they want to read it, let them just read it.
Witness suffers from selective amnesia when he is cornered. It is there on any phone. Just read it. Read the section. 6, you read.
Okay. Section 6, Your Honor talks about functions of the authority.
Yes.
Here means IPOA.
Yes.
That the functions of the authority shall be 6A, investigate any complaints related to disciplinary or criminal offenses committed by any member of the service, whether on its own motion or on receipt of a complaint, and make recommendations to the relevant authorities, including recommendations for prosecution, compensation, internal disciplinary action, or any other appropriate relief, and shall make public the response received to these recommendations. Shall I continue?
Yeah, anywhere where the death of a person in police, specific and so on. My question is specific. Can we allow the witness to read?
This is a question.
Sorry, Your Honor.
Before you even say that, this is a question that has been put to this witness. It is about what he has said in his affidavit. He is being asked to justify why he is here and what gives him the powers. The state, who has not been asked a question, can now stand and start giving him answers or start supporting him. Let him answer.
Mr.
Yes.
You have
Yes, Your Honor, I just wanted to indicate. Section 6 has been referred to in the affidavit. The witness has been asked to read, he has read the affidavit. The witness is being asked about the law supporting an action which is not in the affidavit. That's where the difference is. The witness is saying that Section 6 allows us to do A, B, C. But counsel is asking, does the law allow you to do A, X, which is not in the affidavit? We believe that by him having cited to us the paragraphs he would ask questions on, asking the witness about the law allowing you to investigate deaths in cell, which we have not referred to in the affidavit, is going outside the affidavit. But we would be guided.
So it's a bit of condition. So let him answer. If it falls under the ambit of that section 6, let him
Yes,
just say
that's right,
it
that's right,
falls
that's
under
right.
that provision in the law, and let's leave it as that.
That's right. That's right.
And the question we are here about is specific to death inside a police cell. And that is all I'm saying. If he says that section, then the court will go and make a ruling out of it. That's all we're asking. In relation to death in a police cell.
In police custody.
It's not you to set my question. I've asked you my question. You can't set a question and answer yourself.
So, Mr. Jibril,
Yes.
If it's not there, it's not there.
the question is, do you have the powers to investigate?
We have powers to investigate death that occurs under police custody.
And that's good enough.
Yes,
That's
and custody includes
The
cells.
report has gotten what we have asked. The question has been answered. We'll do submissions on it. That's all. Let's go to paragraph. Paragraph 7. You have paragraph 7?
Yes.
Read to the court what that paragraph says.
Your Honor, the paragraph says that the respondent was arrested on 13th June 2025 by DCI officers and subsequently handed over to IPOA and was later booked at Langata Police Station via OB 50-13-6 of 25 at 18:05 hours.
The DCI officers arrested him at what time, according to your there?
He said around 3.
You read exactly what you're saying.
I've not indicated the time.
That's I'm asking.
Yes.
It is not indicated when the DCI officers arrested.
Yes.
Where did they arrest?
At the DCI headquarters.
And not Eldoret.
No, Your Honor.
Found that the accused was not arrested at Eldoret. The respondent.
According to the officers who handed over me to Mr. Taalam, the officers informed me that they arrested him at the DCI headquarters.
Thank you. I'm putting to you that IPOA released a false information to the public that he was arrested in Eldoret en route to escape to Uganda.
That is not in my affidavit.
I'm saying what is in social media is that the respondent...
Your Honor, I can only answer what is in on this affidavit.
Sorry, Your Honor.
Let's not digress to those issues.
Yes.
Yes.
Let's proceed on the question of arrest. Are you aware the Director of Criminal Investigation, my friend Mr. Mohammed Amin, said the respondent is a person of interest?
That is not in my affidavit.
That's why I said, are you aware? If you are not aware, you are not aware.
Counsel, please ask me what is in this affidavit. I'm not going to, Your Honor, I'm not going to answer anything outside the affidavit.
I put it to you that based on the DCI mentioning the respondent, on that day at 2 p.m., he presented himself to the DCI headquarters in the presence of his advocate, Juan Keton. Were you aware of that?
If you said so.
And the DCI authorized these officers together with the advocate to present the respondent to IPOA headquarters.
Your Honor, we have said time and again.
I'm putting it to you.
Please,
You don't need to answer.
please answer me ask me what is in my affidavit. Let's stop charges, Counsel.
Counsel, I've only put it to you, I've not asked you the question.
Is it in my affidavit? The question I'm asking to you is it in the affidavit? The answer is no.
Of the court, I'm putting to you, then I'll ask you where you're saying you are arrested.
Your Honor, I will decline to answer anything which is not in my
I've not
affidavit.
asked. I've not asked.
Then please ask.
I put it to you that the officers handed over the respondent to IPOA in the presence of Mr. Keto. As I put it to you, for the record purposes.
Samson Taalam was brought to IPOA head office by DCI officers.
And he did record a statement at IPOA in the presence of his advocate, Juan Kiprono. Who is it?
Is that in my affidavit?
I'm putting it to you, counsel. You are a counsel. When it's a question, I'll ask you a question. I'm
Please-
only putting it to you
please ask
for knowledge
me questions.
purposes. So now, if those are the facts, look at the paragraph you said he was arrested. Paragraph 7. Now I'll ask you questions from there. Read.
I have read and read. What is the question, please?
It's a long day.
No, it's a long day, yeah? It's okay. It's okay.
The state is rich, it can bring water.
Yes.
For both of us and council. It's a long day. Can you confirm that paragraph 7 is not true, that he was arrested by the DCI officers?
The respondent was arrested by DCI officers after he presented himself and brought to IPOA.
Do you have any evidence material to that effect? I've given you the scenario the way it was.
No. The fact that he was brought under the escort of DCI officers means he was arrested and brought to IPOA office.
Court has taken that. Let's go further.
So, Your Honor, I think this will be my last objection. We hope that counsel is not proposing to court that he has an alternative set of facts which the court should take note of, because counsel is not a witness. If he wants to give us his alternative facts, we would expect an affidavit so that we also put him on a dock and cross-examine him. Until then, the only factual matrix we have is the one given by the witness before court.
The only way to prove falsehoods is by bringing facts that are truthful. The affidavit is full of falsehoods. We are putting exactly the scenario, and your witness has not recounted any.
So, sorry. Your Honor, I am a believer on the law and procedure. What I understand by the law of affidavits is that a person cannot give us factual matrix, especially a lawyer or an advocate, from the bar. Right now, we have affidavit evidence given by this officer. We are having an alternative set of facts, which may be true. We have no reason to doubt it. But until we have an affidavit, all that is telling us is, I put it to you. And we hope it does not go to evidence.
Just to allay your fears.
Yes.
The evidence that I'm documenting is from you.
That's right. Thank you very much.
Not from Mr. Johnson.
Thank you.
Because as you put it rightly, he's not giving evidence.
Correct.
He knows the procedure.
Thank
That's
you.
why.
He's a teacher of the law.
Yes, thank you. And that's why I told you, which now is mature to be a judge of the high court. Thank you very much. Let's proceed, Your Honor. Paragraph 9.
Yes, Your Honor.
Paragraph 9.
Yes.
You have said what? About the position of the OCS?
Now, the respondent at the material time of the incident, he was officer commanding Central Police Station, exercising command of the Central Police Station, hence persons of influence, and has capacity to interfere with the ongoing investigations and likely witness.
Do you have any evidence to show that he was in full command at the police station?
As an OCS, that is...
I've asked a simple question. It is either you have it or you don't have it. Do you have anything, either duty roster or something showing he was on duty or in command?
Your Honor, what the advocate is asking is that you are the presiding magistrate here. Do you have the power of this court? I mean, once you are an OCS, you have got the power over that station. Come on, counsel.
We have agreed that you don't have it. You are looking for it. Let me put it
And
let me put it to you.
And Your Honor, just to answer also, whatever evidence that I had, I have put as an extra. Anything else which is not here is purposely done to safeguard, first of all, the integrity of the investigations. And they will be provided at the most relevant time. I'm well aware that this will not be the forum where those charges will be preferred. Yes.
So I've asked a simple question.
Yes.
Among the annexures,
there are none.
You produced an annexure showing he was in command of the police station at the time the offense was committed?
I recorded his statement and he confirmed that at the time of the incident he was the officer commanding station at Central Police Station in the presence of his lawyer. I have not attached in this affidavit.
Simple. The answer is clear. You have
Yes.
not attached. All that's what you are looking
Yes.
for. It's not attached there.
And maybe to answer your question, any other attachment that you might ask, it's not there, save for the OB extracts,
Just don't go. And you are a lawyer. When I say I put it to you, don't respond. I've not asked any question.
Then why are you putting in the first place? Why in the first place? You can put it there. You can put it all over.
Really went to law school.
So
and that is-
that's if you don't want answers, those questions that you're putting,
I
you're
know.
putting a lot of putting in.
Yes.
Yona, we have our own label here. Allow us to proceed. What is relevant, record. What is not relevant, leave it. I put it to you, the police station, and the deputy was in command as an OCS.
That is not in my affidavit.
And I put it to you that the OCS was never near Central Police Station.
That is not in my affidavit.
Thank you. The world has had its own. Let's go, paragraph 15. On the question of him likely to plan. You're there?
Yes.
We have agreed there is no any material.
Yes, nothing attached to
Let's
this.
proceed.
Okay.
Paragraph 10.
You go back.
Oh, I asked you paragraph
15,
15.
yes.
I'm going to paragraph 16, sorry.
Okay.
Still no material attacked. It's either very serious material you have kept, no material attacked.
Yes, Your Honor.
Thank you. Paragraph 17 about the CCTV.
No material attached, Your Honor.
Thank you very much. Paragraph 18,
No material attached.
no material attacked. Paragraph 17,
Come on.
I've gone back because there's a question I want to ask.
Yeah, please ask.
You have said about the CCTV cameras. Do you have possession of the scene of crime as of now?
No.
Who is in possession of the scene of crime?
The scene of crime was processed and released. Remember, that's a police station. You cannot hold a station as a crime scene for a very long time. So we have released to the relevant authorities.
Is that on oath? Because I was there yesterday. It's not true that the scene of crime has been released to the police.
Then
Is it still a scene of crime, or it is non-operational police station?
that question is not. It's not in my affidavit.
You've run very fast. Do not lie that is it. So you cannot, there's no material to show that.
Nothing attached, Your Honor.
Paragraph 19. You've read it?
Yes, Your Honor.
And 21, they are the same.
What's the question? No material attached.
There is no material attached.
Yes.
That is very, very critical to us. Paragraph 22. I still ask you this question about the blue code of silence.
I will refer you to the High Court decision.
Tell the court. This is a lawyer. He knows High Court decision.
Court of Appeal decision.
Give the court that decision.
In the Titus Ngamau case, 2020. It was a phrase coined by the judge who was dealing with that matter.
And I remind you, Cliff is the one who argued that matter.
Yes.
He'll face you over that matter.
It's okay.
He's the one who argued that matter. Cliff will deal with the blue code. Paragraph 23. You are now providing reasons as to why you want him to be detained for 21 days. True? From paragraph 23.
Yes, Your Honor.
What is the reason you want to detain him? In paragraph 23.
That we are yet to record critical witness statements.
Very well. Is his presence required physically when you are recording statements from other people?
His detention is required so he doesn't interfere with the witnesses.
About recording statement and interference are two things. Wakili,
I have responded to your question. The reason as to why I'm seeking that prayer is to have him detained so that he doesn't interfere with the witnesses.
Very well. Does he know the witnesses?
Them being police officers? The answer is yes.
Is there anything you have shown of any attempt to interfere with witnesses? Because, Counsel, you know very well the authorities, the Sagari, Duat Sagari, Cliff will ask you. The questions I'm asking is to prove, have you demonstrated by material your violence?
Nothing attached.
Thank you. Important. Paragraph 24. What are you addressing?
That we are saying if released, his security is not guaranteed due to the public anger demonstrated by the case. I've just read what is in the affidavit.
Yes.
I'm saying that the gruesome murder of the deceased has elicited widespread public anger, and therefore, if released at this point, the respondent's security cannot be guaranteed.
Mr. Witty took us a lot about the case of Oscar Sudi. Heavily. Have you ever had a chance to read paragraph 32 of that decision of Professor Justice Joel Ngugi?
Not in my affidavit.
It's not in your affidavit.
Yes.
For the benefit of doubt, you are saying you want to detain him on two limbs. One, for the safety of his life. True?
Yes.
Do you have anything to show that his life is in danger?
Nothing attached.
Do you have anything to show that he is a danger to anybody of the public?
Nothing attached.
So it is an apprehension.
Yes, Your Honor.
Thank you. It is an apprehension. Lawyers swear to be court officers. It is an apprehension. And you are very aware that the National Police Service is the one mandated to provide security for everybody in this country, including the already convicted murderers. You are aware of that?
Not in my affidavit.
No. You will fail to be not understanding what I'm asking. I'm asking you this question. The duty to protect life and property falls under the police.
If you say so.
And the And lastly, you have already attached the order in your application. Look at it. We have an order. True. Makori, this is a competent advocate and witness.
No, I'm just.
I have seen an annexure here.
Can I check? Yes.
I've seen an annexure there. You are given an annexure that has. Is it yours?
Yes.
Or it is on it?
No, it's ours.
Very well. Let me ask you the question. You are certain you are getting these orders?
Council.
No.
It's a draft.
Which is saying, is the office of the DPP or a power that gives the orders, or is the landed court? What is the import of you drafting an order? Is it a formality? That in this court, already you have decided, not the court decides? Who decides? Who decides? I hope it ceases.
I hope we can save time by admitting that the application was drawn by the office of the DPP. What we have annexed as an order is a draft order. It is not the first time today, is it 18? It has been done since I was a law student at the University of Nairobi, where we do draft orders. The court can reject it, it's not binding on the court. So that we save time for counsel and his client.
We have only for good practice.
We admit.
Avoid doing the judicial work. Leave the courts to do their works.
Let's not done so much on that here. Yes. I think what Mr. Witt is saying is just practice that they have adopted from the DPP's end, which is not a good practice.
It is not a good practice.
So let's leave it at that.
If I sat in that office, I wouldn't allow that. I was chased. Thank you very much. Let me allow Mr. Kangai to proceed. Oh, sorry, you know what I said? If an advocate is not allowed to talk, I will be stoned out. Put Mr. Shadrach on board. He has just left class to come out. He was teaching till he's late on the forum.
It's our
We just try to let you know that it should be a difficult one. After Mr. Shadrach, Mr. Kiketo will play his legal cases. Then I'll wrap the application. I think Mr. Umbeta and Mr. Njui will be waiting after submission on that.
Your Honor, with your permission, I will ask very few questions to my colleague, Mr. Jibril. Unlike my seniors are on the software. And I hope you are around so that you don't ask again the same questions which I have already answered. Yes, I teach law. Let's relax. Yes.
The problem is his body. Cliff, make sure he eats well.
Thank you. Thank you. Mr. Jibril, I want you to confirm to the Honorable Court that indeed one person of interest in the matter surrounding the death of the late Albert Ojwang is the Deputy DIG Edward Lagat. Please, repeat the question. I want you to confirm to the Honorable Court that the late Albert Ojwang was arrested pursuant to a complaint made by the DIG, Mr. Edward Lagat. Yes, Your Honor. Thank you.
you also want to confirm to the court that from your preliminary investigations, the late Albert Ojwang was arrested and put in police cell, largely due to the complaint that was made by Mr. Eliud Lagat. Is that correct?
Yes, Your Honor.
Thank you. You confirm to the court that the investigations you seek time to continue with are investigations meant to assist you to unravel the persons who should be held culpable for the death of Albert Ojwang. Is that correct?
Yes, Your Honor.
Thank you. Please inform Your Honor the name of the chairperson of the body where you are coming from.
Your Honor, I think we have agreed that what I'm going to answer is what is...
Of the Constitution allows for limitation of rights. Under the Constitution, save for the rights under Article 25 thereof. So that while we acknowledge that the respondent has a right to freedom, right to security of his person, and a right to liberty, all those rights fall outside Article 25 and can be reasonably limited. Where there is justification. And where, Your Honor, it is established that the kind of limitation we are seeking in the nature of detention continuing is the least restrictive measure. So that, Your Honor, once we have established, as we have, that Article 24 permits the limitation of the right to freedom and liberty, then we shall, through my learned senior, take the court through our affidavit to establish the justification. But, Your Honor, Article 49(1)(f)(1) sorry, that is 49(1)(g), Your Honor, I'm sorry. And if you allow me to read, an arrested person has the right at the first court appearance to be charged or, and this is important to us, informed of the reason for the detention continuing or to be released. And so out of the three available options under Article 49(1)(g), we have come to court to seek detention continuing. Your Honor, with that legal basis, allow me to make a reference to the learned Joel Ngugi J, as he then was, in Sudi Oscar Kipchumba.
The DPP is making submissions. They waive the right of making submissions after we have made our submission, so that once they have done this, they will surrender to this for cross-examination. And they have the right.
Procedurally, it is the deponent,
be put on the dock and the deponent is cross-examined, the respondent's lawyers submit, and the state submit. But now it's the reverse. And that's why I'm asking, is my good JV abdicating the role?
My understanding is that he was just laying a basis so that once the deponent comes to the dock, then they can proceed from there. Yeah. So let JB just finish with your laying your basis. I believe it's more or less like an opening statement.
He has done an opening statement.
Yes, let him finish.
Then be doing an opening statement to lay the basis,
yes,
and counter what I've been saying, because he's doing actually an opening statement. We'll also be seeking that we also put an opening statement and before the police.
So please.
Sorry, Your Honor. I do not understand the basis of that argument, because we are arguing our application with both facts and the law. So I'm doing the law, then my colleague will do the facts. It's the same thing if we started with the facts. So I'm almost done with the law. But sometimes he does that to take me off-road, and he knows I never get off-road. So, Your Honor, I was inviting the court to paragraph 24 of the very erudite decision of learned Justice Joel Ngugi, which sets the test required for the grant of the order of detention continuing, which my other colleagues prefer to call custodial orders. And it says, at paragraph 24, if you permit me to read, so, even while accepting that the text of Article 49(1)(f) may, in certain circumstances and contexts, and we submit like this one, comprehend a situation where a person is presented before a court without being formally charged, and is thereby informed of the reasons for his continued detention through the state's application, like ours, to have him so held, the state must satisfy a double test. A, first, the state must persuade the court that it is acting in absolute good faith, and that the continued detention of the individual without a charge being preferred, whether provisional or otherwise, is inevitable due to existing exceptional circumstances. So that, Your Honor, through the factual matrix, we are going to establish exceptional circumstances. And B, this is the second part of the test. Second, the state must demonstrate that the continued detention of the individual without charge is the least restrictive action it can take in balancing the quadruple interest. You know, this is very interesting. Quadruple interests present in a potential criminal trial. There is a potential criminal trial, and this is the quadruple interest. Number one, the rights of the accused individual, in this case the respondent, who is likely to be charged in a potential criminal trial. Number two, the public interest, order, and security. You know, it is not in doubt that this is one of the great matters of the greatest public interest in the country at the moment. Number three, the needs to preserve the integrity of the administration of justice. We will discuss that in a minute. And finally, and the interests of victims of crime where appropriate. And Your Honor, the court, in cracking its head about it, continues to say, by virtue of Articles 21(1) and 259 of the Constitution, the court must act to aggrandize, not diminish, the personal liberties of arrested individuals in line with the other three interests. But importantly, differently put, the state must demonstrate that there are compelling reasons to deny pre-charge bail, while balancing all factors within the complex permutation presented by these quadruple interests, and without reifying or essentializing any. Yon, I dare say kizungu kubwa. Having highlighted those two tests, Your Honor, the state is acting in utmost absolute good faith to have presented the respondent within a reasonable time before court. Other than in the police cells, through the affidavit before you, the respondent has been informed, one, of the reason of his arrest, and two, of the reason why the state seeks to continue to detain him. That is a show of utmost good faith. Your Honor, in insurance law, it's called uberimai fidei. That good faith is furthered by the fact, as my learned senior will tell you in the facts, or rather in the affidavit, that there has been some investigations ongoing and that we just need a limited period within which to complete those investigations. And finally, from my part, in compliance with the need provided for under Article 24 of the Constitution, that the limited detention of the respondent is the least restrictive measure we could adopt to protect both the interests of the respondent, the victim's interests, and as equally important, the interests of the public to ensure safety and security. You know, with that legal background, I invite my learned senior, Mr. Jalson Makori, to take you through the factual matrix in the affidavit. I am most obliged unless there's a question for me.
All right,
thank you.
Your Honor Makori, Your Honor, we are referring to the affidavit by one Abdurrahman Jibri. Abdurrahman Jibri, dated the 16th of June 2025. It is an affidavit in support of the notice of motion, dated the 16th of June 2025. Your Honor, I'll only highlight the paragraphs that are in the affidavit. Paragraph 6 sets out the background of the investigation, and these are the preliminary investigations by IPOA, which reveals in paragraph 6A to E, 6A to E, that is on the 4th of June 2025, the DCI received a complaint from the DIG of police, Mr. Eliud Langat, alleging he suffered continued false and malicious applications on an X account, formerly Twitter, with the username Pixel Pioneer, and requested investigations with a view to establish the person and motive behind it. Your Honor, A to E establishes the grounds in which the investigations were mounted. It is at paragraph 6D. On the 7th of June, the DCI team went to Linda Center in Homa Bay County and arrested the deceased at around 2:30 p.m. And they took him to Mawengo Police Station, placed him in custody with the OB number 10/7/7/6/2025.
Read it again. 10/7/6.
That is 10/7/6/2025. Then at around 3:54 p.m., the deceased was booked out under OB number 11/7/6/2025 and escorted to Nairobi, where he was booked at Central Police Station under OB 136/7/6/2025 at 9:32 p.m. Your Honor, we have annexed to paragraph 6E the OB extract, that is AJ1, indicating the time that the deceased was booked at Central Police Station. Paragraph 7, Your Honor, the respondent was arrested, and this is something that would wish the court to take notice. The respondent was arrested on the 13th June 2025 at 18:05 hours, that is 6:05, which was on a Friday. The respondent in paragraph 8 was informed of the reasons of the arrest and for which the reasons and of the offense that is being investigated. That is under paragraph 8. Your Honor, in paragraph 10, now we are coming to the reasons why we want to continue holding the respondent. The respondent is the custodian of the station records, an OCS, officer commanding station, and the surveillance system, the CCTV. And this is at the material time under the investigations.
What will be the respondent telling us?
Your Honor,
the information the DPP is giving, it's not them who depend. It is the one who depend who should be giving us those paragraphs.
We can talk about it because the
then
matter
the
is here.
DPP can address their submissions based on that. Right now, the DPP is turning himself into a witness.
No.
We cannot close the exam with the DPP. It is fair and just. The witness who the poem takes us through is undone.
Your Honor, as I said that I'll only highlight a few paragraphs which I wanted the court to take note of.
You know, that's a
Because-
it's a dicey situation because
Yes.
you're literally taking us through the but I leave because I'm sure you have your own strategy
Yes.
on how to prosecute the application.
The defense
But to details
Yes.
of the fidelity, I'm sure the
Why not?
the
They're
defense
the ones who
have a chance.
Yes.
So I leave it to proceed, but I don't go too much into it. Position.
You can hit this one.
No, Your Honor, I'm only highlighting some paragraphs. I'm not going through the whole affidavit because they have already indicated that they want the deponent on the dock for cross-examination. Yes, Your Honor, what we are...
CCTV, maybe
Yes, the CCTV, yes, we say paragraph 10, the respondent is the custodian of the station records and the surveillance system, that is the CCTV, that is under investigation. Yes, investigations reveal that under paragraph 11, that the respondent, together with others who are not before court, hired a technician to interfere with the CCTV system at the Central Police Station in a bid to tamper and interfere with the subsequent investigations. Your Honor, we are highlighting what so far we have done insofar as the investigations are undergoing. So there is still some investigations which we need, and that is the reason why we are asking for continuing detainment of the respondent, because the respondent's mobile phone has been detained. And it is subject to investigations. Your Honor, there are also witnesses who are yet to be investigated and statements taken from them. Also witnesses, police officers who are on duty at Central Police Station on that night. Your Honor, given that OCS, we are saying that there is a likelihood that he may interfere with the investigations. We'll be seeking the 21 days.
I had forgotten to hit on that issue about be allowed warrants to access their phone. You've mentioned it, but please just hit it. In addition to the 21 days, you're also seeking an order to access the phones.
To continue holding the respondent, and in addition to the 21 days, Your Honor, we'll be seeking an order that we access the phones
Number 18, 17 and 18.
of potential witnesses, the police officers who are on duty, and any other person who was at the vicinity at Central Police Station. And this, Your Honor, we are relying upon paragraph 17 and 18, where we have shown in the paragraphs, we have demonstrated that there is already interference which has already been done. With that, Your Honor, we will be inviting the deponent, the doc, for the cross-examination.
Whenever you're comfortable.
Yes.
Yes. But these are standing to an opening statement. Will be allowed at 3 minutes opening statement.
So let it finish. Let it finish, and then have the chance. So that
Let me see that and yes, please.
Bismillahirrahmanirrahim. I swear by the name of the Almighty God, the evidence I shall give before this court, touching the matter in question, shall be the truth, the whole truth, and nothing but the truth. So help me God.
You state to the court your full name.
Your Honor, I am Abdurrahman Jibril. Jibril for you, Jibril. I'm a Senior Assistant Director, Investigations with the Independent Police and Oversight Authority.
Yes, you own this affidavit and before court.
Yes, Your Honor.
Yes, kindly proceed with the affidavit. There will be questions given from the defense.
Thank you, Your Honor. Your Honor, I am one of the investigating officers in the ongoing investigations that IPO is currently conducting in regards to the brutal murder of Albert Ojwang. This is pursuant to Section 6, 7, and 25 of the IPO Act. Your Honor, on 8th day of June 2025, IPOA learned the death of Albert Ojwang while in police custody at Central Police Station within Nairobi County. Your Honor, the authority immediately initiated investigations to unravel the circumstances surrounding the gruesome death of the deceased. Your Honor, so far, our preliminary investigations have revealed that the deceased was arrested following a complaint by the Deputy Inspector General of Police.
Your Honor, all that the witness is saying has been said. You can only adopt the process. Because unless there's any other crucial information.
That's not right. That's okay.
Yeah, we'll talk with you, but just give a highlight. Yes. Not necessarily going paragraph by paragraph. Just a highlight, and then we can adopt it. Just a brief highlight.
Okay.
You okay with whatever you've said so far?
Yes.
Whatever you've heard in the affidavit. Yeah. So we can proceed with the cross-examination.
Yes.
Is that okay?
That's actually not that. Okay. They can proceed to examine on the affidavit.
Thank you. Your Honor, I'll be asking the witness, Mr. Jibril.
So, Mr. Johnson, maybe just for housekeeping good order, how many of you will cross-examine?
3.
3. You, yourself, and who else?
Me, what? Kangai.
So only 3 of you?
Yes, we'll cross-examine him. The others will submit. Thank you. Mr. Jibril.
Yes, Your Honor.
Can you confirm your position at IPOA over this matter?
You are asking my rank?
Yes. Okay. That's what I'm asking.
Your Honor, as indicated, I'm a Senior Assistant Director, Investigations.
And confirm that you are an investigator.
Yes, Your Honor.
Are you an investigator in the purpose and the name or position of the National Police Act?
IPO Act.
Under IPO Act. And under IPO Act, is it true that you have still arrested powers?
Yes.
Under which section?
Your Honor, Section 7 of the IPO Act and Section 7 of the IPO Regulation Act actually gives me the powers, privileges, and immunities of a police officer.
So Section 7. And which section?
Both Section 7 in the IPO Act and Section 7 of the IPO Regulations Act.
Gives you the powers as that of a police officer.
Yes, Your Honor.
And in this matter, you are now actively participating pursuant to those provisions as an investigator.
Yes, Your Honor.
Thank you. Are you well conversant with the law?
Depends on which area you want to ask.
Are you, you know, some of us went to teach, then we became lawyers. Some people are mad about that. Do you have any legal training?
Yes, yes I do.
Could you refer the court to your legal training?
I'm an advocate of the High Court of Kenya.
Thank you. You are an advocate of the High Court of Kenya. Look at the Criminal Procedure Code, Section 386, as an advocate of the High Court of Kenya. Could you be given it?
Your Honor, we'll have an objection.
I've not asked the question.
We can see. Your Honor,
I've not asked your question.
Your Honor, at least should I be allowed to make the objection?
Of course.
Let me just object, then you...
No. You wait until I ask. I'm just told to look at it. It might be just to admire it.
Your Honor, we'll be requesting the court to be answered. Yes.
Let's hear his objection.
Okay,
That's right. Your Honor, the witness before the doc has come here on the basis of his affidavit on the factual matter, and that explains why the defense requested that my colleague, my learned senior, does not go into the facts. Section 386 of the Criminal Procedure Code, or whatever provision of the law, is a matter of law. And then the objection again goes into the earlier intended preliminary objection, which we have had sight of, where the argument, in a sense, is that this matter, now we have had a copy, although it's not filed, this matter should have been the subject of an inquest and not a miscellaneous application. So that because we are alert, the defense should not try through the window to bring in a preliminary objection which they admitted not to have filed. But more importantly, that this is a witness of facts, not a witness of the law. We can deal with the law between the lawyers. Thank you.
That's Your Honor. Is the law a fact? Yes, it is. Is he in a court of law? Yes, he is. Is he an advocate? He knows it. What is it that they are appearing and telling us they are coming through the window? If we come through the window, please respond and throw us out of the house.
There is a submission. I've not asked any question. I've only told him to look at that section.
But just for guidance, it's a matter of evidence on the facts. And it's an affidavit for heaven's sake. So let's leave it to the facts of it.
After I've asked the question, then that is when an inference can be done, whether it's a question of law or a question of fact.
Right.
I've not asked what. I've only told him, look at section 380.
Just one more thing. The reason we requested the defense at the very onset to inform us of the paragraphs is that the cross-examination is limited to the contents of the affidavit. There is no reference to section 386 in the affidavit. They cannot go to it because it is not a matter of fact. If you pointed to us the paragraph looking at section 386, which we referred to, there will be no objection from our end. But because affidavits are pleadings of fact, we plead with you to reject the invitation of the witness to look at section 386 or any other provision of the law. Thank you.
This will revise section 386.
Yeah, I just only
So,
told you to.
let's not convolute it, yeah? Let's limit, it's an affidavit.
Purely, I've not asked any question, Your Honor. If we only had what I've asked you, and I ask a question of law, then the court can stop.
Okay, then proceed and ask.
Let him have that. Let him look at what I've
Once
done.
you point it to the law, then it means...
No.
And that exactly is our objection, that we can't refer to the law. That is, maybe, see, a counsel is not understanding our objection.
Very well.
Maybe counsel, maybe rather than asking him to look at the law, yeah, why don't you put the questions to him?
Correct.
Put the question,
Correct.
rather than, us going
Very
to
well,
the...
very well. From your affidavit, confirm the place of death of the late.
Central Police Station cells, Your Honor.
Central Police Station cells. From the POA Act, provide the mandate for you to investigate somebody dead in a police cell.
Yes, Your Honor.
Read, show the court. Because you have confirmed the scene of death is at the police cell. Which mandate gives you that power? Let him answer.
We are still objecting. Council is still taking the same route.
He came under the Act. You know, section in this miscellaneous application, paragraph 3, they must have said under which mandate they are coming before this court. And this is a witness. He's not an advocate. Let him come in front. Let him not be given answers.
No, Your Honor. We plead with our colleagues to just remain respectful. We know that they are very good people. Let us maintain the decorum. What we are asking is, as the court has suggested, put the law to the witness. Don't ask the witness to refer to the law.
Very well.
We do not mind if you read the law to him and ask questions.
Read paragraph 3 of your Act.
Please read for me so that I can answer.
No, you read it. I didn't write it.
Which one?
Paragraph 3.
That investigations by IPOA are pursuant to section 6A, 7.1 and 25.1 of the IPOA Act.
Is that the law?
Yes.
Is that a fact or that is the law?
That is a fact as per this affidavit.
That's what I'm saying.
Yes.
You have quoted the law. True.
Yes.
Therefore, it is not wrong to ask you a question of law because it is yours in your affidavit talks the law. Give me the law that gives you mandate to investigate a person who dies in a police cell. That is simple.
I have indicated the sections 6.1, 7.1.
Just tell the court.
Yeah, I have indicated section 6A, 7.1 and 25.1 of the IPOA Act.
Could you kindly read to the court those sections that gives you that mandate? The IPOA, just read to the court those sections for the benefit of the whole world. We don't work for IPOA.
Because we did not anticipate that a witness of fact will be made to read the law, we didn't carry a copy of the IPOA Act. If they insist that they want to read it, let them just read it.
This from selective amnesia when he is cornered. It is on any form. Just read it. Read the section. 6, you read.
Okay. Section 6, Your Honor talks about functions of the authority.
Yes.
Here means IPOA. That the functions of the authority shall be 6A, investigate any complaints related to disciplinary or criminal offences committed by any member of the service, whether on its own motion or on receipt of a complaint, and make recommendations to the relevant authorities, including recommendations for prosecution, compensation, internal disciplinary action, or any other appropriate relief, and shall make public the response received to these recommendations. Shall I continue?
Yeah, anywhere where the death of a person in the police cell, specifically, must question is specific.
Your Honor, this
Can he allow the witness to read?
This is a question.
Sorry, Your Honor.
Before you even say anything, this is a question that has been put to this witness. It is about what he has said in his affidavit. He is being asked to justify why he is here and what gives him the powers. The state who has not been asked a question can now stand and start giving him answers or start supporting him. Getting answers.
Mr.
Yes. Yes, yeah, I just wanted to indicate. Section 6 has been required in the affidavit. The witness has been asked to read, he has read the affidavit. The witness is being asked about the law supporting an action which is not in the affidavit. That's where the difference is. The witness is saying that Section 6 allows us to do A, B, C. But counsel is asking, does the law allow you to do AX, which is not in the affidavit? We believe that by him having cited to us the paragraphs he would ask questions on, asking the witness about the law allowing you to investigate deaths in cell, which we have not referred to in the affidavit, is going outside the affidavit, but we would be guided.
So let him answer. If it falls under the ambit of that section 6,
That's right. That's right.
And the question we are here about is specific to death inside a police cell. And that is all I'm saying. If you say that section, then the court will go and make a ruling out of it. That's all we're asking. In relation to death in a police cell.
In police custody.
It's not you to set my question. I've asked you my question. You can set the question and answer yourself.
Yes.
If it's not there, it's not there.
the question is, do you have the powers to investigate?
We have powers to investigate death that occurs under police custody.
And that's good enough.
Yes, and custody includes
The court has answered what we have asked. The question has been answered. We do submissions on it. That's all. Let's go to paragraph. Paragraph 7. You have paragraph 7?
Yes.
Read to the court what that paragraph says.
Your Honor, the paragraph says that the respondent was arrested on 13th June 2025 by DCI officers and subsequently handed over to IPOA and was later booked at Langata Police Station via OB 50-13-6 at 18:05 hours.
The DCI officers arrested him at what time, according to your there?
You said around 3.
You read exactly what you're saying.
I've not indicated the time.
That's what I'm asking.
Yes.
It is not indicated when the DCI officers arrested.
Yes.
Where did they arrest?
At the DCI headquarters.
And the nota Eldoret
No, Your Honor.
found that the accused was not arrested at Eldoret.
According to the officers who handed over me to Mr. Taalam, the officers informed me that they arrested him at the DCI headquarters.
Thank you. I'm putting to you that IPOA released false information to the public that he was arrested in Eldoret en route to escape to Uganda.
That is not in my affidavit.
I'm saying what is in social media is that the respondent...
Your Honor, I can only answer what is in this affidavit.
Sorry, Your Honor.
Let's not digress to those issues.
Yes.
Yes.
Let's proceed on the question of arrest. Are you aware the Director of Criminal Investigation, my friend Mr. Mohammed Amin, said the respondent is a person of interest?
That is not in my affidavit.
That's why I said, are you aware? If you are not aware, you are not aware.
Counsel, please ask me what is in this affidavit. I'm not going to, Your Honor, I'm not going to answer anything outside the affidavit.
I put it to you that based on the DCI mentioning the respondent, on that day at 2 p.m., he presented himself to the DCI headquarters in the presence advocate 1 Keton. Are you aware of that?
If you said so.
And the DCI authorized these officers together with the advocate to present the respondent to a headquarters.
Your Honor, we have said time and again.
I'm putting it to you.
Please, please answer me, ask me what is in my affidavit. Let's stop chatting, Counsel.
Counsel, I've only put it to you, I've not asked you the question.
Is it in my affidavit? The question I'm asking to you is it in my affidavit? The answer is no.
Of the court, I'm putting it to you, then I'll ask you where you're saying you are arrested.
Your Honor, I will decline to answer anything which is not in my affidavit.
I've not asked.
Then please ask.
I put it to you that the officers handed over the respondent to IPOA in the presence of Mr. Keto. As I put it to you, for the record purposes.
Samson Taalam was brought to IPOA head office by DCI officers.
And he did record a statement at IPOA in the presence of his advocate, Juan Kiprono. Who is it?
Is that in my affidavit?
I'm putting it to you, Counsel. You are a counsel. When it's a question, I'll ask you a question. I'm only putting it to you for knowledge purposes. So now, if those are the facts, look at the paragraph you said he was arrested. Paragraph 7. I'll ask you questions from there. Read.
I have read and read. What is the question, please?
Cool your temper. It's a long day.
No, it's a long day, yeah? It's okay.
You said it's rich, it can bring water.
Yes.
For both of us and counsel. It's a long day. Can you confirm that paragraph 7 is not true, that he was arrested by the DCI officers?
The respondent was arrested by DCI officers after he presented himself and brought to IPOA.
Do you have any evidence material to that effect? I've given you the scenario the way it was.
No. The fact that he was brought under the escort of DCI officers means he was arrested and brought to IPOA office.
Court has taken that. Let's go further.
Sorry, Your Honor, I think this will be my last objection. We hope that counsel is not proposing to court that he has an alternative set of facts which the court should take note of, because counsel is not a witness. If he wants to give us his alternative facts, we would expect an affidavit so that we also put him on a dock and cross-examine him. Until then, the only factual matters we have is the one given by the witness before court.
The only way to prove falsehoods is by bringing facts that are truthful. The affidavit is full of falsehoods. We are putting exactly the scenario, and your witness has not recounted any.
Sorry. Your Honor, I am a believer on the law and procedure. What I understand by the law of affidavits is that a person cannot give us factual matters, especially a lawyer or an advocate, from the bar. Right now, we have affidavit evidence given by this officer. We are having an alternative set of facts, which may be true, we have no reason to doubt it. But until we have an affidavit, all that is telling us is I put it to you, and we hope it does not go to evidence.
Just to again you here.
Yes.
The evidence that I'm mentioning from you.
That's right. Thank you very much.
Not from
Thank you.
He's not giving evidence. Yes, he knows the procedure.
That's why
he's a teacher of the law.
Yes, thank you. And that's why I told you, which now is mature to be a judge. Thank you very much. Let's proceed, Your Honor. Paragraph 9.
Yes, Your Honor.
Paragraph 9.
Yes.
You have said what? About the position of the OCS?
Now, the respondent at the material time of the incident, he was officer commanding Central Police Station, exercising command of the Central Police Station, hence persons of influence
and has capacity to interfere with the ongoing investigations and likely witness.
Do you have any evidence to show that he was in full command at the police station?
As an OCS,
I've asked a simple question. It is either you have it or you don't have it. Do you have anything, either duty roster or something showing he was on duty in command?
Your Honor, what the advocate is asking is that you are the presiding magistrate here. Do you have the power of this court? I mean, once you are an OCS, you have got the power of that station. Come on, counsel.
We have agreed that you don't have it. You are looking for it. Let me put it to you.
And Your Honor, just to answer also, whatever evidence that I had, I have put as an extra. Anything else which is not here is purposely done to safeguard, first of all, the integrity of the investigations. And they will be provided at the most relevant time. I'm well aware that this will not be the forum where those charges will be preferred. Yes.
So I've asked a simple question.
Yes.
Among the annexures,
there are none.
You produced an annexure showing he was in command of the police station at the time the offense was committed.
I recorded his statement and he confirmed that at the time of the incident he was the officer commanding station at Central Police Station. In the presence of his lawyer. I have not attached in this affidavit.
The answer is clear, you have not attached. All that's what you are looking for. It's not attached there.
And maybe to answer your question, any other attachment you might ask is not there, save for the OB extracts.
Just don't do it. And you are a lawyer. When I say I put it to you, don't respond. I've not asked any question.
Why are you putting it in the first place? Why in the first place? You can put it there.
You went to law school and that is... I know... We have our own legal theory. Allow us to proceed. What is relevant, record. What is not relevant, leave it. I put it to you that there was the police station and the deputy was in command as an OCS.
That is not in my affidavit.
And I put it to you that the OCS was never near Central Police Station.
That is not in my affidavit.
Thank you. The world has had it, so to me. Let's go paragraph 15. On the question of him likely to plan. You there?
Yes.
We have agreed there is no any material.
Yes, nothing attached.
Let's proceed.
Okay.
Paragraph 10.
You go back.
Oh, I asked you 15.
Yes.
I went to paragraph 16, sorry.
Okay.
Still no material attacked. It's either very serious material you have kept, no material attacked.
Yes, Your Honor.
Thank you. Paragraph 17 about the CCTV.
No material attached, Your Honor.
Thank you very much. Paragraph 18.
No material attached.
No material attached. Paragraph 17. I've gone back because there's a question I want to ask.
Yeah, please ask.
You have said about the CCTV cameras. Do you have possession of the scene of crime as of now?
No.
Who is in possession of the scene of crime?
The scene of crime was processed and released. Remember, that's a police station. You cannot hold a station as a crime scene for a very long time. So we have released to the relevant authorities.
Is that on off? Because I was there yesterday. It's not true that the scene of crime has been released to the police.
Then,
is it still a scene of crime or it is non-operational police station?
That question is not, it's not in my affidavit.
You've run very fast. You not lie that is. So you cannot, there's no material to show that.
Nothing attached, Your Honor.
Paragraph 19. You read it?
Yes, Your Honor.
And 21, they are the same?
What's the question? No material attached.
There is no material attached?
Yes.
That is very, very critical to us. Paragraph 22. I still ask you this question about the blue code of silence.
I will refer you to the High Court decision.
Tell the court. Which this is a lawyer, he knows High Court decision.
Court of Appeal decision.
Give the court that decision.
In the Titus Ngamau case, 2020. It was a phrase coined by the judge who was dealing with that matter.
And I remind you, Cliff is the one who had that matter.
Yes.
He'll face you over that matter.
It's okay.
He's the one who had that matter. Cliff will deal with the blue code. Paragraph 23. You are now providing reasons as to why you want him to be detained for 21 days. True? From paragraph 23.
Yes, Your Honor.
What is the reason you want to detain him? In paragraph 23.
That we are yet to record critical witness statements.
Very well. Is his presence required physically when you are recording statements from other people?
His detention is required so he doesn't interfere with the witnesses.
Avoid recording statement and interference are two things.
I have responded to your question. The reason as to why I'm seeking that prayer is to have him detained so that he doesn't interfere with the witnesses.
Very well. Does he know the witnesses?
Yes. Them being police officers? The answer is yes.
Is there anything you have shown of any attempt to interfere with witnesses? Because counsel, you know very well, the authorities, the Sagari, Duat Sagari, Cliff will ask you. The questions I'm asking is to prove, have you demonstrated by material your violence?
Nothing attached.
Thank you. The court has said. Paragraph 24. What are you addressing?
That we are saying if released, his security is not guaranteed due to the public anger demonstrated by the case.
Okay.
I've just read what is in the affidavit.
Yes?
I'm saying that the crucial murder of the deceased has elicited widespread public anger, and therefore, if released at this point, the respondent's security cannot be guaranteed.
Mr. Witty took us a lot about the case of Oscar Sudi. Heavily. Have you ever had a chance to read paragraph 32 of that position of Professor Justice Joel Ngugi?
Not in my affidavit.
It's not in your affidavit?
Yes.
For the benefit of doubt, you are saying you want to detain him on two limbs. One, for the safety of his life. True?
Yes.
Do you have anything to show that his life is in danger?
Nothing attached.
Do you have anything to show that he is a danger to anybody of the public?
Nothing attached.
So it is an apprehension.
Yes, Your Honor.
Thank you. It is an apprehension. Lawyers swear to be court officers. It is an apprehension. And you are very aware that the National Police Service is the one mandated to provide security for everybody in this country, including the already convicted murderers. You are aware of that?
Not aware of it.
No. You will fail to be not understanding what I'm asking. I'm asking you this question. The duty to protect life and property falls under the police.
If you say so.
And this country is not a banana country where the rule of law has broken. So it is not right to say you are preserving his life in cell and he pays taxes. Everybody pays taxes to be protected. And that it will be dealt with in the cases that I've talked about. Now, what other reason do you need him in cell to detain him for 21 days? What do you specifically want him to do?
All I've said in my affidavit.
Is there any other? If an advocate is not allowed to talk, I will be stoned out. Put Mr. Shadrach on board. He has just left class to come out. He was teaching here in his left on the forum.
So, Mr. Kadai is Mr. Shadrach.
We just try to let you know that it will be a difficult one. After Mr. Shadrach was getting in place legal cases, then without the application, I think if Umbeta and Undi will be making a submission on that one. Your Honor, with your permission, I will ask a very few questions to my colleague, Mr. Jibre. Unlike my seniors are on the software. And I hope you are around so that you don't ask again the same questions which I have already answered. Yes, it's like each law, just relax.
Mr. Jibre is a witness.
Yes.
The problem is his body. Cliff naturally eats one.
So that we can avoid repetition.
Thank you. Mr. Jibre, I want you to confirm to the Honorable Court that indeed one person of interest in the matter surrounding the death of the late Albert Ojwang is the Deputy DIG Edwin Lagat. Please keep the question. I want you to confirm to the Honorable Court that the late Albert Ojwang was arrested pursuant to a complaint made by the DIG, Mr. Edwin Lagat. Yes, Your Honor. Thank you. You also want to confirm to the court that from your preliminary investigations, the late Albert Ojwang was arrested and put in police cell, largely due to the complaint that was made by Mr. Edwin Lagat. Is that correct? Yes, Your Honor. Thank you. You confirm to the court that the investigations you seek time to continue are investigations meant to assist you to unravel the persons who should be held culpable for the death of Albert Ojwang. Is that correct? Yes, Your Honor. Thank you. Please inform Your Honor the name of the chairperson of the body where you are coming from. Your Honor, I think I've agreed, but what I'm going to answer is what is in my environment. Just listen, no. This is cross-examination. I decline to answer that question, Your Honor. It is in public domain. Who is the head of IPOA? Just respond. What is your work here? I'm responding. Please respond. Who is the chairperson of IPOA? What is your work? My response is it is not in my affidavit. Just inform me.
Your Honor, we have agreed that I will be cross-examined on what is in this agreement. The chairman of Independent Policy Oversight Authority's name or his position is not in my affidavit.
But you come from that back.
Yes. Yes.
So it's
And the council knows who is the chair of the IPOA.
Please answer the question. Who is the head of the body where we hail from?
We don't have a head. IPOA does not have a head.
Who is the chair of the
Yes, that should be a right question. The chair of IPOA is one Ahmed Hassan Issa.
Thank you. Thank you. Now, you confirm to Your Honor that there was a joint press conference on the 9th day of June 2025. Is that correct?
Your Honor, I'm not going to answer anything outside my evidence.
Your Honor, if you permit me, just to also give context why I am asking this question. Your Honor, my learned senior and friend, Mr. J.V. Owiti, went to a very large extent in explaining the authority that was made by my Lord Professor Joel Ngugi in the Oscar Sudi case. Some of the parameters that were set by the Honorable Court were two. I think that is paragraph 24 of that authority. On the question about bad faith, the question about exceptional circumstances, and lastly, the balance of the quadruple rights that the court should look at. One of the items that we have a duty and responsibility to prove to you is to demonstrate to you that indeed there is an element of bad faith in the application that has been made before you. And that is why my questions are aimed at eliciting some of these facts based on the evidence that is going to present before you. So, Your Honor, I plead with humility that counsel, my colleague, I even suppose is my senior. My senior should just be kind enough to also say, yes, looks are deceitful, but
whatever you have knowledge, just answer it. If you don't have
Your Honor, let me say this. Let me say this for the record. No, let me say it for the record. Your Honor, protect me. The counsel who's on the floor asking questions should only answer. Learned senior should stop looking at me. You will have the time to ask the questions if you require. The second, Your Honor, the second point I'm making here is that anything outside this affidavit, whether our chair is not within my knowledge, and please stop asking me. Anything outside this, I'm not ready to answer. It's not within my knowledge and belief. And after all, Your Honor, the application we are making is about the extension of continued detention of the suspect. It's not about what happened on the backyard. What you are pointing is bad faith.
that's why you said
Please confirm to Your Honor that there was a joint press conference on the 9th day of June 2025 where the chairperson of IPOA, was in the company of Mr. D.I.G. Eliud Lagat and Inspector General of Police and others. We are not aware. Thank you. So you have no information that indeed your chairperson held a joint press conference with one of the persons who has been constantly mentioned in the death of the late Albert Ojwang. You have no information, isn't it?
Johanna, the chair attends several press conferences.
Leave those several.
I don't follow the chair.
Thank you.
I don't follow the chair for his press conferences.
Thank you. Now, that is very important. You have been very honest with the court. Now, I want to return to paragraph 27 of your affidavit. Yes, paragraph 27. You have made mention that the reason why you are inviting the court to order the pre-charge detention of the suspect before court is because you have fear that he might run away from the jurisdiction of this court, isn't it?
Yes.
Have you, in your well-elaborate affidavit, demonstrated an instance where probably he was invited, he never turned up, or you have proof that he has already booked a ticket to a certain foreign land that is presented before court?
That is not in my affidavit.
No, you have in your affidavit. No,
I'm saying,
yes.
The answers that you are looking for is not in my affidavit.
No, I am asking a very straightforward question likely to attract a yes or no.
Yes.
I am asking you again. In lieu of the paragraph 27, on the question about the temptation by the suspect to run away from the jurisdiction of this court, if allowed his liberty, have you provided before this court any material?
No.
You don't have any material?
No.
Thank you. That should be all for me. Thank you. The two of them actually going to take very limited time in form of 2 minutes. So when I can do 125 years, depending on Now, Mr. Jibril, I want you to remember the testimony that you've given us just a few minutes ago, when you told us that the scene of crime was processed and released to the relevant authorities. Is that still your stand?
No, it's not in my affidavit. That's my answer. Yes.
You made a representation to this court and told us that the scene of crime was processed and released to the relevant authorities. Is that correct or not correct?
No. Your Honor, the scene of crime I'm talking about.
Correct or not correct?
The cells where the deceased died has been processed and released to the relevant authorities.
Thank you. Now, can you tell us the investigative steps that you have used to preserve the CCTV and the occurrence book?
The occurrence book is a digital. It's not.
It's a digital one.
It's a digital book. Yeah.
Is it with your possession right now?
No, it cannot be.
It cannot be.
It cannot be in possession.
Have you extracted the relevant entries on that particular day?
Yes, and attached to the video.
Thank you. Now, number 2, about the CCTV, can you tell us the preservation measures that you've taken to preserve the sanctity of that CCTV footage?
Your Honor, we are a team of investigators. That aspect is being done by the forensic team.
So you can also confirm that the CCTV itself is not with the police station. It is with the forensic team.
And what was extracted is the only DVR. But the entire, you can't carry a whole screen.
Okay, that's what I want you to tell me.
Yes. What was extracted is only the DVR.
Yes.
Yes.
So the DVR that records the events of that fateful day is the forensics team.
Yes.
Thank you. That's all.
Good afternoon.
Can you allow me to ask you just 3 questions? I want to take you to paragraph 6A. received a complaint from the Deputy Inspector General of Police. Confirm?
Yes, Your Honor.
Was it an oral complaint or a written complaint?
It was a letter, a formal, yes, a letter to the DC.
Provided that letter this time?
No, it's not attached here.
It's not attached here.
Yes.
Thank you. Kindly go back again to paragraph 7, where you say the respondent was arrested and under the Lamata police station, OB number 50.
Yes, yes, Your Honor.
Who booked the respondent at Lamata police station?
The booking was done by myself.
It was done by yourself?
Yes.
Thank you. Are you aware of the law governing the booking of a person at the police station?
As per the IPO Act, yes.
As per the IPO Act?
Yes. And the regulations.
For instance, are you a police officer or a former police officer?
I'm not a police officer. I'm an IPO employee.
Police officer?
Yes, I've been a police officer.
You have been a police officer?
Yes, Your Honor.
Thank you so much. Paragraph 21. Now, paragraph 21, you're saying there are co-conspirators. Confirm?
Yes.
Do you know the co-conspirators by name?
That is part of investigations. I cannot reveal it.
No, I'm just saying, do you know by name, not their names. Do you know them by name? Because you have said there are co-conspirators. Do you know them? Not by name.
Okay, so Council, this is what I will say. Let me answer. The thing is like yes.
Just say yes or no. Do you know the co-conspirators?
The matter is under investigation.
Yes or no?
As of now, no.
You don't know them? Thank you so much. Now, you have said there was the murder of the deceased was planned, executed, and their attempts to cover up. Do you know the people who are trying to cover up to get the deceased?
One of them is your client.
Do you know that with certainty?
Yes.
Have you provided evidence to that effect? Or the attempt to cover up?
It's an investigation but not attached to this evidence.
You have said yes, you know the client is one of the people trying to cover up. My question is, have you provided evidence that he is one of the people who is trying to cover up?
As of now, no.
No?
Yes.
Thank you so much. Thank you, Honor. That is the
I think that will be the end of the examination of the witness. We will learn now it is once he is discharged, it will remain the basis for our next line of approach.
We lie a few minutes of the exam because that follows cross-examination.
Yes, Your Honor.
My work is to calm you down completely.
Actually, I'm calm and composed.
Now, I will limit my questions back to the contents of your affidavit, many times by paraphrasing.
Okay.
What is the basis of your request for detention continuing in one line?
To complete my investigations.
On a scale of 0 to 100%, how much could you, by approximation, attach to your investigations up to now, on a scale of 0 to 100%? Doesn't have to be accurate, approximation.
49%.
49%. So I can mathematically say this as direct evidence that you're saying there is 51% of investigations to be done.
Yes, Your Honor.
so that there are questions about who is in charge of the cells, who is in charge of who is in command of the station. Do those questions relate to the remainder of the investigations?
Yes, they do.
Now, to ask another direct question, are the questions of the defense some of the things you need to investigate to complete your investigations?
Yes, Your Honor.
Thank you very much, Your Honor. I'll hand over to Mr. Jackson.
It's just one question, the information. You have been asked whether you have attached any document relating to, I think it was paragraph 6A, some paragraphs in your affidavit, whether you have attached anything to show that even the respondent is a flight risk. Why do you need the respondent in custody? Is there any reason why you have not attached?
Yes, Your Honor, the reason I have not attached what I've collected so far, the 49% I'm talking about, is that it will jeopardize the investigations. And it's actually to protect the integrity of the investigations. That's why we cannot divulge much.
Thank you very much. I believe that is all from my end.
Thank you, Your Honor.
I'm glad that you confirmed that you are down.
Yes.
Thank you.
And allow the next phase of part 2. Now we consider check out
It depends how you
you are all asking for the benefit of
how many will be submitting.
the scripture is Lamat, the teaching.
You okay with that?
We are fine. The only thing that we'll be asking is there something that has been filed so that you can be served, or it's an oral.
Let's see what they've done.
Yes, very well.
If there's anything you can do.
We'll serve you with authorities, simply. Our team serve
So just like brevity, this issue is valid in itself. So this brevity, just direct to the judge.
Your Honor, for the record, I remain Felix Keaton, and also there's also another additional attorney at law, Vincent Yegon, also is part of the defense team. Present, Your Honor. Your Honor, we reiterate that we vehemently oppose the motion application dated the 16th of June 2025. And from this motion, Your Honor, there is only one salient issue for determination. That is whether there are compelling reasons for trial or pre-charge detention has been settled in law, is well settled in law. And in fact, Your Honor, Article 49(1)H and 49(1)G of the Constitution is very clear that an arrested person
has a right to be released on bond or bail unless there are compelling reasons. Your Honor, in order to conceptualize and also problematize the issue, Your Honor, permit me to refer you to the statute, which is section 36A of the CPC, of the Criminal Procedure Code. And in order also to contextualize the issue, Your Honor, is that this section 36A was an amendment following the locus classicus in Michael Rotich, that is in Michael Rotich versus Republic, the 2016 decision, whereby, Your Honor, in this section, it lays the two-tier threshold for such an application to succeed. The first burden, Your Honor, is on the investigation, that is the IPOA. And the other also burden also, Your Honor, rests with the Honorable Court. And as I said, Your Honor, under section 36A, it is very clear that pursuant to Article 49(1)(f) and (g) of the Constitution, a police officer shall present a person who has been arrested in court within 24 hours after being arrested. And now it lays now what the investigation officer must do. First, he must make an application in writing. First, he must produce the suspect in court, which they have done, which we have done that. Then the second thing, Your Honor, is that they must apply in writing, and they have done that through this motion application. But now, Your Honor, the greatest issue that we must also do, Your Honor, is that under section 36A clause 3B, it states that the investigation must also adduce the reasons necessitating the continued holding of the suspect in custody. So the question that begs our attention at this juncture, Your Honor, is whether there are reasons necessitating the continued detention of the respondent. And we submit, Your Honor, in negative, that the investigations have not adduced any cogent reasons necessitating continued detention of the respondent. And Your Honor, my learned friend, we have already gone through the examination limb by limb in the entire affidavit. But if you may permit me only to refer you to 2 or 3 salient issues, Your Honor, in order to illuminate why this motion application is bereft of meat and substance to stand on. First, Your Honor, I'll refer you, Your Honor, to look at paragraphs 9, 10, 11, and 20 of the affidavit. They are building a case that you should continue detaining the respondent because he is likely to interfere with the investigation. We submit, Your Honor, that this is not a cogent reason. And we invite you, Your Honor, to consider the authority which we are provided, that is Republic versus Mercy Chebet. It is a 2022 decision whereby Justice Gigonyo has indicated succinctly, and I will humbly refer you, Your Honor, to paragraphs 17, 18, and 19 of that decision, whereby the High Court has set the law that for such a threshold to succeed, the investigations must tender material information to the Honorable Court to demonstrate the nexus link that is between the respondent and the likelihood of interference. And I will also refer you, Your Honor, to also adopt the reasoning of Justice Mutuku in Republic versus William Chishtil and Godfrey Kirui, whereby the same thresholds.
Your Honor, this is not an objection. It's an humble plea that counsel shares the decision with us, and that it is generous enough that he also points out the paragraph that is paraphrasing, so that we are able to respond there.
Your Honor, we have already filed our list and digest of authorities, dated in 16th of June 2025, and you can confirm, Your Honor, that they are there. The decisions and everything we have already furnished. It's the last decision. Cancel the one which is on the thing is down.
Sorry. I'm looking at your document, sir. I am alert.
Thank you.
The document written respondents list and digest of authorities.
Yes, you are.
I'm looking for Mercy Jabet. You are it.
There is another one which is it's not is the one you are holding.
Thank you. No, this list does not have Mercy Jabet. Does it have it?
You already have an authority, the one next to your phone.
You know what we are informing the court is that we don't have it in the list. So if he has added it, that's okay. That's what you're asking.
Then we don't have the authority, Your Honor. You are already furnished.
I can do it for myself to supply.
Yes.
I think I'm comfortable.
Yes.
I have the message there.
Yes.
And I got the William one.
Yes. 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 So Your Honor, if I may,
Did you count as a William?
it appears there was an oversight, Your Honor, but I know the court was judicial notice of all the citation or all the authorities which we have already provided the citation, Your Honor. So when I was interfered with the floor of my first, I am not in that business like my colleagues. So what you are saying, Your Honor, at paragraph 17, Justice Gigonyo has laid the threshold and also eliminated that interference with witness undermines the criminal justice system and dents the integrity of the criminal process. And he goes on and also says that for such a ground to succeed, the prosecution must tender or must present material information to the head of the court. And the IJAABU decision we have also cited, Your Honor, the William Chishir case, whereby Justice Mutuku has said that there should be a nexus between the respondent and also the stated interference, Your Honor. So that was the main ground, Your Honor, that has been advanced at paragraphs 9, 10, 11, and 20 of the affidavit. Another look, Your Honor, of the affidavit is that, Your Honor, I will humbly beg to refer you to paragraph 24 of the affidavit, whereby you have been told, Your Honor, that the gruesome murder of the deceased has elicited widespread public anger and outrage leading to demonstrations which at times have been destructive. Hence the safety and security of the respondent cannot be at this point be guaranteed if released on bail. So in order, Your Honor, to demonstrate that such a reason, Your Honor, should not hold waters is that we will humbly beg to refer you to the same decision of Justice Gigonyo, that is Republic versus Mercy Jabet, whereby at paragraph 20, which is also titled Safety and Security of the Accused Person, the judge recommended, Your Honor, at paragraph 21, that I have lamented time without number, and again, slide into grief. How and why in this age and time should people take the law into their hands to harm the accused? The community herein is within the territorial jurisdiction of the Republic of Kenya, a nation governed by law and order. And under the Constitution of Kenya 2010, I wonder whether the same community will derive the authority to harm or kill a suspect under trial. No one is above the law or should take the law in their hands. All are bound by the Constitution which reigns. And the community in question should let the law punish the accused. He should stop, and my view is that ground that the security of the accused is threatened by the members of the public or victim family should never, and mark my words, Your Honor, should never be encouraged to be a ground for denial of bail. Otherwise, the court will inadvertently promote or condone violence, disorder, and usurping of law by individuals or group of people. We say no more, Your Honor. Such ground should fail in limine. The High Court has settled the law on that. On the other hand, it is even the duty of the police to also guarantee the safety of the respondent. And you have also been told other issues, Your Honor, that we need time to do forensic, to subject the judges to forensic, etc., etc., etc. We submit, Your Honor, that all those reasons that have been given, it can be done without the need for any custodial order. So we submit, Your Honor, that from all the reasons that have been abused, none is cogent and none should pass the master of the law, because they have already done what they ought to have done, and any proposed investigations can be done without the need of subjecting the respondent to custody, Your Honor. Having submitted the law, Your Honor, that they have failed to demonstrate the reasons necessitating further or continued detention of the respondent, Your Honor, we submit on the second lien, whereby their statute also, Your Honor, has also given the court the latitude of guidance on what you do. And we shall invite you, Your Honor, to consider Section 36, Clause 5 of the Criminal Procedure Code, whereby it is stated that a court shall not make an order for the remand in custody of a suspect under subsection 5 unless there are compelling reasons for believing that the suspect shall not appear for trial, may interfere with witnesses or the conduct of investigations, or commit an offense while on release. So, Your Honor, even submitting that they have not abused that reason, there is a duty that the court also must also satisfy itself before granting any custodial order, that there are compelling reasons that the suspect will not appear during the trial. And there is no such reason that has been advanced by the state, Your Honor. And the other aspect of interference, Your Honor, we have already submitted that there are no material information to persuade you that there is a need to further detain the respondent, Your Honor. And we will say, Your Honor, on the duty imposed on the court in the two-tier threshold, that is the threshold in the second tier threshold, which is the duty of the court, we invite you, Your Honor, to adopt the reasoning of Justice B.J. Otieno. That is a High Court decision in Ramadan M. Hassan versus DPP. It's a 2017 decision, whereby at paragraph 15 of that decision, Your Honor, it is at pages, you have found that authority. It's at pages 43 to 46 of our bundle, whereby the judge reasons this way, Your Honor, that I must add that a judicial officer before whom an application is presented seeking to limit the enjoyment of a suspect's fundamental freedom akin to the right to liberty is duty bound and enjoined by law and the Constitution to be extra vigilant and not to interrogate whether the facts presented to it merit the dictate and spirit of the law invoked before it and are in consonance with the attributes and real philosophy of the Constitution, which guards against arbitrary and unjustifiable limitation or enjoyment of rights and fundamental freedoms. So Your Honor, we humbly persuade you to adopt that reasoning to be extra vigilant in granting such an application, Your Honor, because this being a temple of justice, Your Honor, you hold that mighty sword of Damosil, and you should always strike for the rule of law and nothing else. So having demonstrated, Your Honor, the two-tier threshold, that it fails in every length, we inversely submit, Your Honor, that on the other hand, there are compelling reasons to release the respondent on bond or bail. And we will humbly invite you, Your Honor, to consider certain factors. Number one, Your Honor, is that the respondent before you cooperated with the investigation. I accompanied him, Your Honor, on the 11th of June 2025, when he was summoned by the Independent Policing Oversight Authority to record a statement under inquiry. And he did so, Your Honor, and he was released. Thereafter, Your Honor, he also presented himself to the DCI headquarters on 13th of June 2025, whereby, Your Honor, he sought assistance to be escorted to the IPO offices to see whether he is required there or not. And indeed, in my company, he was escorted, Your Honor, and he presented himself, and he cooperated, and he agreed even, and he was duly booked at Lamata Police Station, Your Honor. So he has already cooperated, Your Honor. That is a factor which you should consider in granting him, Your Honor. The other factor which we invite you to consider, Your Honor, is that there is already issued in place an interdiction letter, which is duly signed by the National Police Service. And Your Honor, in order to put into perspective, an interdiction letter, Your Honor, is a sworn in a real document. We set certain conditions, which is a replica of the conditions imposed under section 36A of the CPC, and also, Your Honor, which technically it holds in abeyance the powers of a police officer. In other words, Your Honor, it removes the thief from him. He can't do anything. And from that interdiction letter, Your Honor, which I had a privilege of seeing as anatomy, Your Honor, he has been told categorically that he should report to the OCS, to the Elliot Police Station. So there is also a condition, Your Honor, to demonstrate that is not a flight risk. There are already safety mechanisms which have been imposed by regard to the interdiction letter, Your Honor. We also invite you, Your Honor, to consider the primary consideration of bond and bail. That is to secure the release of an arrested person, as and when required. And respective of the issues, Your Honor, whether there will be any intended charges or anything, he is still an arrested person within the meaning of Article 49 of the Constitution. And as such, the rights under Article 49 has been activated. And such rights, Your Honor, should be enjoyed to the greatest extent possible. And in interpreting, Your Honor, and in contextualizing the situation, Your Honor, we will humbly persuade you to adopt an attitude that is beneficial to the suspect rather than the state. And in doing so, Your Honor, I will humbly invite you to adopt the philosophy of Justice Kimaru, C. Benwas, in my Corporative versus Republic, whereby, Your Honor, it's an affected from pages in pages 22 to 26. Whereby the judge here, at least in this vision, Your Honor, conceptualized and also reiterated the importance of liberty being in precious. That are personal liberties, right to liberty should be respected at all times unless there are legal reasons for such person to be deprived of his liberty. And the police should only arrest a person when they have a prima facie evidence that an offense has been disclosed which can result in such a person being charged with a disclosed offense. Your Honor, the reason why we are setting this decision for avoidance of doubt is to reiterate the importance of liberty. It's not about the holding charge. So even in their response, Your Honor, they should not deal with the holding charge. This was being, Your Honor, I had a period of interacting with this decision, Your Honor, when my then client, Major Rotich, may his soul rest in peace, was arrested and we went all the way to High Court. And the court made certain findings, Your Honor, including one holding charge and his liberty. But the holding charge question, Your Honor, has already been, there is a mutation of law. So that is no longer applicable, Your Honor, and we shall demonstrate the reason why that decision is no longer, the question of holding charge is not applicable, is because of the second decision, which we have also furnished you, that is in Kenneth Omondi, Ojwang, and 38 others, whereby the same judge also reiterated and eliminated the law, knowing that there was a development, because between that my Corporative and this Kenneth Omondi decision, Your Honor, there was an amendment to section 36A of the PC. So we drastically changed the law. That's why we will also adopt the reasoning of the judge that the reason why this court in the Michael Rotich case required a charge or a holding charge or provisional charge to be presented to the court when the prosecution is seeking extension of time was first to inform the arrested person of the likely charge that he or she may face, and secondly to inform the court on the serious nature or otherwise of the charge. So that was the reason in that development of the jurisprudence, Your Honor. So in grounding our application, Your Honor, and also we'll also invite you to consider another factor, Your Honor, that the suspect before you, the respondent before you, is still presumed innocent. That is verse 1 to Article 49, I think 1A, 52A of the Constitution, whereby he is presumed innocent unless otherwise proven. So no matter the veracity, the public pressure or anything, Your Honor, he is still presumed innocent. So we'll also invite you to consider that one, Your Honor. And finally, also we'll also invite you, Your Honor, to consider that is not a flight risk. Yes, fixed aboard, both within Nairobi and also in Eldoret. And it has not even been demonstrated also that is a flight risk. So those are the issues, Your Honor, that we'll humbly invite you to consider in granting him bond or bail, Your Honor. And we'll humbly beg to ground our application on that under paragraph 3 to 5 of the bail and bond policy guidelines, which will guide you especially on the situational analysis. And we also beg to ground our application also, Your Honor, and to support the same also as per the decisions which we have cited, which we have already provided. That is the authorities, especially the Court of Appeal in Jayendra Gimji Malde versus Republic, whereby the Court of Appeal settled the issue and reiterated the constitutional provision that an arrested person has a right to be released on bond or bail unless there are reasonable reasons not to be released. And also the Court of Appeal has also reiterated that now, unlike in the past, even those persons charged with serious offences such as murder are entitled to bail on reasonable conditions. And the applicant here is certainly entitled to that bond, Your Honor. And also on that other issues also, Your Honor, which you have been told that there are compelling reasons, except the question of interferences, safety and interest, Your Honor. We'll also humbly invite you, Your Honor, to adopt the reasoning of Justice Mativo in Republic versus Zanfo Kabage, and I know my learned senior Cleveland Better also argued that matter, whereby the High Court has laid the test of compelling reasons. That compelling reasons or grounds ought to be proven to the satisfaction of the court, and mere allegations or possibility is not enough, and bail cannot be refused simply because the accused has been charged with a very serious offense, and that the burden of proving such to the court that there is one or more grounds rests solely with the prosecution, and there is no time whereby the burden can shift to the respondent, Your Honor. We'll also rely on the other decision which we have tendered, Your Honor, the Betty Kimeyua case, which was also a reaction to the Michael Rotich case before the amendment, and we have already furnished to you, Your Honor. And as such, Your Honor, we'll invite you to decline the application before you because the same is bereft of meat and substance to stand on, and to invite you to unleash your sword of Damocles and to strike for the rule of law and to admit the respondent to bond or bail. And we'll humbly, Your Honor, suggest that he be released on cash bail or 7,000 shillings. That is what he can afford, because we also know the conditions of those of Kenya. And also, Your Honor, in also making your ruling, Your Honor, we'll humbly invite also you, Your Honor, to make certain policy or in your dictum to find or to make certain policy considerations. Because the reason why we are here, Your Honor, is also because of the legal edifice of IPOA, which is created under the Independent Policing Oversight Authority Act number 11 of 2011. Whereby, Your Honor, I wish, as the people of the Republic of Kenya, we had constitutionalized or made IPOA one of the commissions or independent officers under Article 248 of the Constitution. It would have been good. But what the Parliament did in that Act, Your Honor...
Sorry. You know, Mr. Keaton, who is a good friend, appears like a law teacher, like my friend Shadrach Wambui. What he's inviting a court to do, which is now justifying, is beyond the jurisdiction of this court. You cannot make policy. So he should just save us time so that we go to what this court can do. Although he had a very good point, but this court has nothing to do with it.
It was just an dictum observations, Your Honor. And this is why they do that one. They know that in what the Power Act, what the parliamentarians did was to establish a way that...
Your Honor, we have objected to that time.
It's okay, Your Honor.
This court has no jurisdiction.
I withdraw, Your Honor, and we humbly beg to submit, and I beg to rest my submissions and raise their questions for me.
Okay, thank you.
Thank you.
I've really appreciated your industry.
Thank you, Your Honor.
You've argued it so eloquently.
Thank you, Your Honor.
And erudite.
Thank you, Your Honor.
So I believe the others will not have anything to say.
It is Langat. Good afternoon, Your Honor. I'll only go straight to what my colleagues on the other side submitted earlier in the opening statement, and more specifically on the case of Sudi Oscar Kipchumba versus the Republic. The decision which I believe they will share with you, I've just looked at it and analyzed while sitting here. These are decisions that, in essence, will allow you to dismiss the application today. I'm happy because they are the ones who brought this decision. It's a very beautifully done judgment, ruling. The tests that they have been argued by my colleague under Article 49 are found in this ruling. I want to address one or two issues. The first one is the aspect of the investigations. They have made a picture, or they have painted a picture that our client is likely to interfere with investigations. Your Honor, today, the witness, in his affidavit and while being questioned in examination in chief and in re-exam, has told this court that they are in control of certain important exhibits which are not within reach of our clients. There is no way you can interfere with those items, exhibits, which are in control of IPOA. Your Honor, the second aspect, which I believe will be addressed by my learned seniors, is the aspect which came out in the affidavit, the issue of forensic analysis. The forensic analysis of the phone, the gadgets, will be done and shall be done in the absence of our clients. IPOA has officers capable of doing that job conclusively without any input from our clients. The attempt by the applicants to say that our client should be in custody while this process is going on should not be entertained by this court. This court, Your Honor, should abide by the binding decision in Professor Ngugi's decision and release our clients on reasonable bail, which my colleagues have suggested, and put even other conditions which our client is willing and ready to abide by. Those conditions, the discretion is with the court. We therefore submit that the application has fallen short of meeting the threshold set by various decisions cited by my colleague and have been supplied to the court, meeting the requirements of compelling reasons. Finally, Your Honor, the affidavit that was filed before this court does not produce, does not even have did not even attempt to convince you for those compelling reasons. With that, Your Honor, I beg rest my case. I'll allow my seniors to have their time. Thank you.
Your Honor, with the greatest of brevity.
Yes.
Your Honor, whereas my good colleagues have cross-examined the veracity of the affidavit as the point. My good colleague, what call him Dr. Kiton, has laid the legal basis, the premise upon which creates a question with the application before you. I'm just reminded before my good colleague, Mr. Ombeta, submits his finality to say that the application notice of motion that is before you seeks in prayer A, B, C, D. One, that the matter be had interparted, which is what is happening right now. It is seeking in prayer B, that the respondent be remanded for 21 days pending completion of investigations. It prays in prayer C, that the electronic gadget seized from the respondent be subjected to forensic examination. And finally, any further orders that this honorable court may deem fit. I am certain, and it's a position we take, that we have no objection to prayer C. If the so would want to examine the gadget, given the fact that they are already seized and in custody of the gadget, as to whether we oppose or not, we would not control what they intend to do. Principally, what Your Honor is being called upon is to give a continuation of detention of 21 days to complete investigations. We submit, Your Honor, that in the deposition of my good friend, Mr. Jibril, that he has since the last 7 days covered 49% of the would-be investigations. I doubt that he would need 21 days to complete the remainder of the 51% of the investigations. Why am I saying this? The persuasion of my good colleagues that, Your Honor, be minded of the provisions of Section 123 of the Criminal Procedure Code, read with the Article 49(1)H, as well as G of the Constitution of Kenya, in matters bail, that you be inclined to admit the respondent to a pre-plea bond condition is the positive aspect that we are all taking, and we have no doubt that Your Honor, clothed with wide powers to make such a determined decision on bail bond, would grant. But in the unlikely event that Your Honor is disinclined to grant bail bond as is being prayed, that you consider that the days so requested for 21 days are days which are more than sufficient for them to rely on. We are saying that the custodial detention should not act as a punishment. Given the fact that you've been told the cooperativeness of the respondent and the clear position of the application before you, as well as the affidavit of one Mr. Jibril, which presents before you no evidence that the respondent is a flight risk, no material evidence as said is placed before you that the respondent is likely to interfere with any witnesses or investigations as they are ongoing. But most importantly, that their wish to have the respondent not granted bail is premised on his own safety. And we would only ask, is the police saying that they are unable to secure and safeguard the safety and interest of its citizens? In the threshold of that, Your Honor, we plead, like my colleagues have pleaded, that to be inclined to grant the respondent bail bond pending this investigation, and I'm minded that he has been cooperative and no indicator has been placed by the investigators or by way of affidavit that he is likely to become uncooperative moving on forward in this particular investigation. And should in both lean as to whether you grant bail, which we hope you do not, that the days sought for completion of investigation are in excess, Your Honor, and that if they are limited, it would not in any way prejudice the investigations, as nothing would bar the good investigators from making a return to this court and seek extension of more or further time so to conclude the investigation. As we oppose that application, we plead with Your Honor that you admit the respondent to bail bond pending this investigation, and in the event of such disinclinement, Your Honor, be considerate to reduce the number of days that the applicant seeks to hold the respondent in custody. Benigni, we submit, Your Honor.
Okay, Your Honor, I was thinking that my colleague Shadra was going to say something. But let me start with whatever he wants to add, he can add. But
the last one,
yes. Okay. Now, Your Honor, let me start first of all by asking that let me request that the court, first of all, Your Honor, grants bail to the accused. I mean to the respondent to this matter. Please grant him. And I'll be requesting the court very humbly to do so. Why am I saying this, Your Honor? It's because now I believe that once they have come under Article 49G and 49(1)H, they have an obligation to give you compelling reasons. It's an obligation. It is nothing less than that. Your Honor, if then they have failed in that particular point, what then becomes of that article? Doesn't it become absolute once they fail? And I'm saying they have failed at least miserably today. Why am I saying this, Your Honor? Because if you look at Article 49, and this one was also in the Republic versus Oyama case, the court has indicated what is supposed to be a compelling reason. That's in paragraph number 23. Tushapatia mingi mkonazi mpaka tumechoka, sio? What does the court say something to do with compelling reason? And this is the Court of Appeal decision in the Oyama versus Republic case. It must be something that is forceful, something that is so convincing, something that is so strong that the court cannot ignore it. Cannot ignore it. Now, Your Honor, once we have seen that, then the state has come and told you they want the suspect or the respondent to be in custody because they want to investigate or they want to have access to his phones. What they do not tell you is that he gave them the passwords and they're keeping quiet about it. And if they want the password, we can give it here in court now
So that point ya kutaka simu is out of the window. Let's finish that one. It's a simple thing, a 1 minute thing, doesn't need 21 days. They tell you that there are CCTVs that are within Central Police Station. And that the suspect, the respondent might interfere with them. But the investigating officer has told you clearly they have taken the material that was required. He called it a DVI. That is the most important one. So what they have there is a shell. And that's the reason why they can't pick it, and that's why the OCS here cannot pick it. So that is the second point. That issue about the CCTV, we kill it right now. They have nothing on it. Then they're telling you they are going to interfere with the investigations. But in his affidavit, and what he has said here on oath, is that, in fact, I've given you a password. Take a password. They're telling you.
So we don't have to break it.
Yes, Your Honor. The issue is not about the SIM or the password. It requires a lot of things.
No. Your participation, watching me. I'm running the show.
Okay.
Now, they're telling you about witnesses. They are not telling you the affidavit which witnesses, but they're telling you something else that is imaginary. That they are yet to get some other witnesses who they are going to record their statements. What does that show you, Your Honor? That the OCS does not have the names of those witnesses or does not know them. Does not know them. Such that if we come then to the issue of witnesses and interference with them, it is finished. One of the reasons that the court wants to grant bail to an accused person is whether he's going to appear in court or will appear where is required. Why is this important? Let us look at the antecedents of the respondent here. When the IO here called him, did he appear? Yes. When he was told to go and record a statement, did he appear? He did, and recorded a statement under inquiry. When the DCI director himself spoke and made some wild allegation in Parliament, the OCS woke up by himself and took himself to the DD police station, headquarters CAT, and asked, do you need anything from me? Look at this kind of person we are talking about. Do you need anything from me? Then they arrested him. Why would you deny him bail, Your Honor, when such a person has exhibited a person who is capable to cooperate and even volunteers before they get those Subarus to go and pick him? He volunteers. So today, we are talking of a person who knows the law and respects it. Those are the grounds that they had for you today, Your Honor. So what else remains? Now let us go back to that issue of the litigation. Then have they convinced you, Your Honor? And I am saying they have not. And that is why I will agree with my learned colleague that if you gave him a cash bill of 7K, that is fine. In fact, for me, I'd say freedom. Because at the time he was going to those officers, he was okay. There was no money, there was no cash bill, but he went. That shows a person willing to come to court. They quote Article 19, they quote all those articles in the law. But you see, Your Honor, today, let us agree. Why do we have these fundamental rights? It is so that we can protect this kind of person from this kind of people. The police. That is why we have these fundamental rights. And Article 19 is quite clear, and it's my favorite, that these fundamental rights, who do they belong to, Your Honor? They belong to an individual and not the state.
not the state. Once they know that those fundamental rights exist, they come to Article 20, which is very clear and says it binds all state organs, including the court, including the prosecution, and including the officers, the police officers. That includes also IPO. If it includes them, today they come with an affidavit and tell you, denying bond on very flimsy grounds. Did they read Article 21? I am certain that they ignored it because Mr. Witty, my friend here, would have told them. And I don't know why he's not telling them, but Article 21 is clear that when these fundamental rights are known to exist, all these arms that I have mentioned, what are they supposed to do, Your Honor? They must start by wanting to grant this fundamental right. Article 20, sub-article. Might start by wanting to grant to ensure that this person enjoys the fundamental right. But they still give me this affidavit. So what do we do, Your Honor? Article 22 is clear. Once we have noted that they are in a position where they want to prevent an enjoyment of these fundamental rights, we come under Article 23 and Article 165. Very clear articles. So that the court, once it has noted this kind of, can I call it, bad faith application, will be able to see. Let me qualify it to say, why does it come under bad faith? You have an IO who has come to court today. What does the IO do? Refuses to answer questions. Tells he will not answer that. He will not say anything. He doesn't know anything. He doesn't even know who his boss is. And he doesn't know whether he attended a press conference. Now, things that are in public domain, and we know them by ourselves. Why should you believe him today? That once you release this person to him, he shall be treated well. Why? You cannot believe him because he denies publicly even his own boss. I know now how Jesus felt when Peter just. And then, you know, if that is a position, and then they come and tell you, oh, this, the republic order and issues like that, and that the safety of this person depends on them keeping him in custody. Where does that come from? Because Article 29 is clear. This gentleman must enjoy his fundamental rights. The security, it is provided by the state. It is guaranteed. Guaranteed. So they can't come here by a mere application and tell you that he cannot be safe. And they don't quote that article in their application. Why? They avoid it intentionally because it is black and white and it is clear. So bad faith again from the investigating officer. And he is my friend. No, Your Honor. I know when the state wants to respond, they will start telling you about probabilities. They want to tell you that nowadays it's on probabilities whether a person will appear or not, that they anticipate. And you can see from their affidavit, they are alleging, they are saying likely to abscond, likely to interfere. It remains likely. Let us change that scenario of likely. Let us move from the bail bond issues first of all. Let us go to what the law says today. Law is very clear, and there are three authorities that I will give the court. One I've already given, the one of Oyamo. Then there is one of Richard David Alden versus the Republic, that is the number 40 something. Oh, you see, I'm even so confusing myself. You know. The High Court case number 48 of 2016. And then the other one is White Sagarite versus the Republic. That is number 61 of 2012 for the High Court. Proudly, let me say that I appeared in the matters. What did the court say when somebody makes an allegation to do with somebody is going to interfere? The court did not say probably. The court said must put evidence, must show something, must produce something. Why? Because if we were to leave it to imagination, the sky would be the limit. So if you are saying somebody is interfering with witnesses, you must show that he directly interfered or indirectly or has attempted. In the affidavit that you have been given, nothing is there. They are saying likely. That was held by Justice Korean in the Dwight Sagarai case and was also supported by Justice Lasit as she then was in the Richard David Alden case. If you're going to say somebody is going to abscond, what does the judge say in Lasit? She says that you must be able to show that an attempt has been made by the person to try and abscond. Not only that, maybe there's a ticket, plans of traveling, or arrangements made. So I'll ask you, Your Honor, and I will give you the answer. Have they given you that? Then the answer is no. Such that even in the case of Oyamo, when they are saying that public order and public interest and all that, the court in Oyamo was the Republic, and this is a court of appeal case, and that is the law. What does it say? For you to say that there is public order and rest and all those things that they are saying, they must show. All this unrest that has been going on has not been because of the OCS. Tuesday, tomorrow, there will be an mandamano in reference to somebody else. Not him.
You know, we hope that goes on record. That matter of fact, we hope goes on record.
It's even on social media. And let me tell you why they can't tell me not to say anything about social media. In his affidavit, he said they got these issues from social media.
You know, if that counsel can go to social media, we're just asking the court that as he says it from social media, please record it for us, we will use it.
Yes, Your Honor. And if that is the position that they are going to say and they are going to use it, let me tell you, Your Honor, it was not in relation to the OCS. It must be mentioned that it is the OCS and it must be accurate. Let us not generalize. That is why that law has never been overturned. Until today, it has never been overturned. So, what then does that leave the prosecution with? An empty shell, Your Honor. Today, they have come to this court, not, as I said, to do this case in a proper manner, but in bad faith, which have demonstrated, and an affidavit that does not meet the requirements of Article 49. And at least what we will come out from with here is that at least I've given them a definition of compelling reasons. Yes. Thank you.
Let me read. Cliff can mislead the court. Your Honor, for the public and the country to get that paragraph, that is the citation. Cliff has said, criminal case number 61 of 2012, Republic versus Dwight Sagarai. In page 4, paragraph 3. Your Honor, the court is saying, for the prosecution, that is a wit, and my good friend Makori, to succeed in persuading you on this criteria, however, it must place material before the court which demonstrate actual or perceived interference. It must show the court, for example, the existence of a threat or threats to witnesses, direct or indirect, incriminating communication between the accused and witnesses, close familial relationships between the accused and witnesses. That is not clear from better say, but it was part of that decision. That is the decision that we are seeking. When I was cross-examining my good brother, he admitted he has nothing, no material.